on the docket. Thank you so
Okay.
much.
So that leaves me, we don't need to.
Nope, you don't have to go there since he refused. He doesn't get a second look. Thank you.
You got it. No. All right, that's it. Just two.
All right. Okay, thank you so much.
Thank you.
All right, so Raj, you can delete Mr. Johnson since he's refused.
Okay.
Thank you.
So that motion is automatically denied.
Yep, however you want to say it, or if you want to deny it, let's deny it instead of he's refused.
Okay.
All right, thank you. So let's go over to any other facilities ready? I know that main jail has a lot, so let's see if we have any of the other facilities.
Look, I was ready, Your Honor. Good morning.
All right, good morning. How are you?
I'm well. How are you?
I'm fine, thanks for asking.
Good. On the second look, if we can please take Mr. Myers out of turn.
Okay, not a problem.
And for medical reasons, Mr. Blatch on page 15.
15. Hold on, let me get there. 15. Oh. Match. Okay, I see it. Thank you.
Now, and also Judge Blackman, on page 10, Arnold Mitchell, we can't bring him down for security, or he's one of our more severe mental health inmates, but he is a municipal ordinance. So I'm going to go over to the unit to see him so you can magistrate him.
Okay, thank you. So just whenever, we'll take him last then, whenever you guys
Yes.
just use the raise hand icon and we'll take him out of turn, okay?
Okay, thank you.
All right, thank you. Okay, I'll just mark my docket with that. What about, thank you so much. What about Paul Ryan? Do we have anybody at Paul Ryan this morning? Okay, perfect. So they don't need to log on. Thank you so much. All right, so let me go over to main jail. Good morning, guys. Last but not least, good morning, Mr. Romero.
Good morning, Judge. I got a couple of things to advise the court. Let me look through the docket now. On page 3, we're going to need a Spanish interpreter for Miss Martin Lopez.
Okay, hold on. Page 3, Spanish. Okay, thank you so much. Miss Edgley, if you could please call for the interpreter. Thank you.
On page 5, after speaking with Shay Ben, she wanted me to waive her appearance.
Page 5. Okay, perfect. Thank you.
On page 8, Joel Velez is a refusal first time. I'm going to be asking for it to be reset for tomorrow.
Page 8, Velez. No, sir. He's being held no bond and a violation of probation. We're going forward without him.
Judge, on page 9, Mr. Michael Nicolosi advised me as private counsel, Mr. Barry Waterman.
Okay, he hasn't logged in yet. Whenever he gets here, we'll check him in. Thank you.
No problem. On page 11, Mr. Daniel O'Shea wanted me to waive his appearance.
Okay, thank you.
On page 12, Mr. Wilbur Contreras wanted me to waive his appearance.
Okay, thank you.
On page 14, Mr. Christopher Scott advised me as private counsel, Mr. Mark Z.
Yes, I was advised of that and that he's going to waive his presence and his client's presence because they were advised by Judge McCarthy of the conditions that she set.
Okay. On page 15, Mr. Mitchell O'Neill wanted me to waive his appearance.
Page 15. Okay, thank you.
On page 15, Mr. Daniel Tuff is a refusal. First time I'm asking for it to be reset for tomorrow.
Okay, no, it's violent, so nope, we're going forward without him.
On page 15, Mr. Robert Sandinato wanted me to waive his appearance.
Okay, got it, thank you.
On page 16, Mr. Montana Ellen Osborne is a refusal on him. No legal objection.
Okay, thank you.
On page 16, Mr. James Peterson wanted me to waive his appearance.
Okay, thank you.
On page 17, Mr. Nicholas Brandau is a first-time refusal, non-violent. I'm asking for it to be reset for tomorrow.
Okay, not a problem. Mr. Linderstate wish to be heard? Okay, that's fine. We'll give him one refusal.
On page 18, Judge, Mr. Jonathan Joseph is a refusal, considering he has no bond holds, no legal objection.
All All right, thank you. We'll proceed without him.
On page 18, Mr. Eddie Butler is a first-time refusal. He's in detox, Judge. These are non-violent. I'm asking for it to be reset for tomorrow.
All right, thanks. Mr. Linder, state wish to be heard. All right, we'll give him one opportunity. Thank you.
On page 19, Mr. Joseph Retta is a refusal, no legal objection.
All right, thank you. We'll proceed.
And on page 20, Mr. Wayne Jones wanted me to waive his appearance.
All right, thank you. He's on another page as well because he does have no bond holds.
Correct. Warrant for violating pretrial, correct.
Yeah, okay, perfect. All right, thank you. Who's the deputy there this morning? I wanted the attempt murder out of turn. That's Mr. Civil on page 15.
Deputy Nelson. Civil. Okay.
Thank you so much.
Judge
All right.
wants another turn. Where's he at? In back? Yeah, he's in back.
If you guys don't mind getting him whenever you get a chance, he's going to be one of the people I call out of turn, please. Do they have any medical that they need out of turn at the main jail, Mr. Romero?
No, ma'am. At this time, no, Judge.
Okay, thank you. All right, so Raj, just
I'll let you know.
the whole stack actually, since it's only 2 cases out of turn, so that's fine. If you want to just give me the stack with the DV paperwork. And I'll slide this back. I'll leave this here for you. All right, do I have any private attorneys that need to check in? Thank you. What's the second stack?
I separate the females and the.
Oh, okay. All right, thank you. All right, not hearing anything, let's get started. Mr. Sinisi, good morning, sir. I do need your services for 1 case, so thank you for being here.
Good morning, Your Honor. My pleasure.
All right, so good morning, everybody. Let's get started. Good morning. It is Friday, July 9, 2021. I'm Judge Tabitha Blackman. We are here for first appearance court. The purpose for today's hearings are for the court to first make a probable cause determination. If that is done, the court is then going to move on to bond release conditions and whether the individual defendants are eligible for bond. The court is not going to touch out-of-county holds, out-of-state holds, signed warrants on violations of probation, or key pieces for the most part. If you are a civilian, please pay attention. This pertains to you. If you're a civilian, please note that not only are these proceedings recorded, but they are live streamed on YouTube. So for that reason, I have taken your cameras off if you're a civilian logged in with yourself unmuted or with your camera on. Please keep your camera off until the case that you're here for is called. You would indicate your presence by using the raise hand icon. You need to have your full legal name listed if you want the court to call on you. I need to know whether you are the listed victim. If you are, then I will turn to you and ask you whether you wish to be heard from or whether you just want to see what happens. If you are not the listed victim, I will not call on you. One of the attorneys would have to call on you to testify. Please do not interrupt these proceedings by either turning your camera on or unmuting yourself, because I will eject you from these proceedings without further warning if you do it multiple times or depending on the severity of the interruption. That being said, I have to call a couple of cases out of turn for a variety of reasons, as well as for the reasons that some people may have attorneys that they've hired who are not permanently assigned to this courtroom. Please do not think anything else other than I am giving those attorneys who are not assigned to this courtroom a courtesy so that they can go to the other courtrooms that they are assigned to. That being said, Ms. Edgley, good morning, ma'am. Did you have any information for me other than what the jails provided me?
Yes, the only one that I have, and I'm not sure if it was already addressed before, but Smith on page 12 will be made.
On page 12. Yes, I believe they told me.
Okay, thank you, Justice White.
All right, thank you. So let's get started. Did you hear that they wanted to take at Conti facility 2 cases out of term, Ms. Edgley?
I did, Judge, that's fine.
Okay, perfect. Let's start at Conti facility.
I have Mr. Cash on page 12.
All right, thank you. Good morning, Mr. Cash.
Good morning, Judge.
I do find probable cause counts 32 and 33 false odor upon items less than $300. Counts 34 and 35 dealing in stolen property. Count 36 is criminal mischief over $1,000 regarding a pretrial monitor. So let me mute this. Ms. Brown, is he on pretrial release? Okay, it's already been revoked. Thank you, Mr. Linder. So Mr. Linder, first to you then. I've already muted this.
Your Honor, I'm just asking that the court keep the bonds in place. Nobody can contact no return. Your Honor, he's actually, you should see this starts with charge 32. He's being held no bond for violation of pretrial on charges 5 through 31. For multiple burglaries, grand thefts, petty thefts. He also has a no bond hold for burglary with dwelling or structure causing damage of $1,000 from the pretrial cases. Based on all this, Your Honor, I'm just asking that the court response.
Okay, thank you. Ms. Edgley?
And Judge, he is currently being held no bond on those violations of pretrial release. He's been a Broward County resident his entire life. He lives in Deerfield Beach and will be returning there if he's able to resolve the violations of pretrial release. Judge, no objection to the bonds, the current bonds that are set, except for counts 34 and 35, I'd be requesting $1,000 bond. Unfortunately, that's all that Mr. Cash is able to afford at this time.
All right, thank you. So I will leave the bonds in place as they have been set in order of no return to the incident location, Mr. Cash, as well as no contact, direct or indirect, with the listed victim. Do you understand?
Yes, ma'am. And that one that you said about the pretrial ankle monitor?
They said that they've already revoked the pretrial, sir, so that's not an issue for me to deal with this morning. You'll have to go before your division judge, okay?
If I bring the monitor back, that burger for the pretrial monitor, that would go away?
I can't give you legal advice, Mr. Cash. Don't talk about the facts of your case. Just be in touch with your attorney regarding that question, because everything you're saying is being recorded and can be used against you, okay?
Yes, ma'am.
All
Thank
right,
you, ma'am.
we'll provisionally appoint the Office of the Public Defender to represent you on these new counts. Once COVID is over, Mr. Cash, you'll need to reapply. Good luck to you, Mr. Cash.
Thank you, ma'am. Have a nice one.
And Judge, I'm also requesting a mental health screening this time.
Oh, no problem. I'll just add a mental health screen, please, for me. All right, not a problem. I will add that. All right, so let's go to the second look at Mr. Belding at Conti facility. Good morning, sir.
Morning.
All right, Mr. Linder, I believe this is the one that was just up the other day at it was a location where he was allegedly using racial slurs before allegedly smashing 2 windows with a hammer, correct?
Correct, Judge. This allegedly occurred at Dania Beach City Hall.
Okay, thank you.
Your Honor, kept the bond in place. Also, according to the reports, he resides or is from the state of Oregon and does not have strong ties to the community.
All right, thank you. Ms. Edgley?
Judge, I would ask that Mr. Belding be released on his own recognizance to pretrial release. He has been residing in Broward County since October 2020. He has no intention of leaving the county and is willing to appear for his court hearings that may happen subsequent if the state elects to file charges in this case. Unfortunately, Judge, he's not able to afford any bond. It's my understanding he doesn't have any criminal history or any history of failure to appear. Accordingly, I'd be asking for him to be released to standard pretrial release.
Okay, thank you. Mr. Linder, correct me if I'm wrong. Did he have priors out of Oregon or other states because he's not from here?
I'm putting I don't remember that specifically. I'm putting his information back in the system.
Okay, thank you.
Yes, Judge. I'm actually getting hits from various states for aliases for him out of Oregon under the name Sidney Rogers. He was arrested on a fugitive warrant from another state. That was in 2014 with charges of unauthorized use of motor vehicle, false info to law enforcement, and making a false report. I'm showing, again, under the name Sidney Rogers with aliases for Joshua Bilski or Bilski, James Pierce, Lyde Rogers, Bobby Joyner, and James Pierce. Counterfeiting. Looks like that was a federal case, 2014. Showing out of North Carolina, under the name Sidney Rogers. Burning personal property, sentenced to we can disregard that. Showing an arrest with no disposition out of South Carolina from 2012 for false information, perjury. Nothing further, Judge.
All right, thank you. Based on that fugitive warrant and the hits out of multiple states, I am going to leave the bond in place. I'm going to take no action. Good luck to you, sir. You can always file a motion with your division judge. All right, so that brings us to North Broward. They had two people that they needed us to take out of turn. It's a second look, so no action.
It's 5.9.
Is North Broward there? All right, not hearing anything, I guess we'll, oh, they're there.
Yes, we're
Hang
here.
on.
Hello?
Yes, I'm here.
All right, who do you want to hear? I'm sorry, we just had.
We can do the second look first. That's fine.
Good morning, Your Honor.
All right, good morning, sir. All right, Mr. Myers, this is a petty theft. It looks like it was originally from 3/30/21. Mr. Luther, can you tell me what's going on, please?
Your Honor, if Mr. Myers wishes to resolve this case, the offer to be an adjudication time served. I'm showing on his other charges he has been state sentenced.
Okay, and where is the incident location? Do you want me to do a no return?
Well, if I can have one moment, Your Honor. Ms. Cooper, does it show in what his state sentence is? Depending on the length of that, Your Honor, I don't know if the no return will be necessary.
20 months. Judge, you got 20 months.
Okay, thank you.
Location,
Walmart. Is the state asking for no return?
I am, Your Honor. Do you have the address there in the PC?
Yes, I see.
Okay.
it. Thank you.
Okay.
And Judge, he is interested in resolving the case and accepting that offer.
All right, thank you. All right, Mr. Myers, raise your right hand for me, sir, to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your hand down and please state your name for the record.
Victor Anthony Myers.
All right, Mr. Myers, it's my understanding you wish to resolve your petty theft charge, correct?
Correct?
And do you understand the charge against you?
Yes, I do.
And do you understand everything that's happened here today?
Yes, I do.
Is anyone forcing you to resolve this case?
No, they're not.
Are you under the influence of alcohol or drugs, sir?
No, I'm not.
Do you need more time to speak to your attorney?
No, I do not.
Do you understand that you are forever giving up your right to go to trial on all the rights that entails by accepting the state's offer?
Yes, I do.
And have you ever been treated for mental or emotional illness, sir?
Yes, I have.
Is there anything about that illness today that affects your ability to accept this plea?
No, it doesn't.
And you're thinking clear-headed today?
Yes, I am.
All right, and I'm not asking if you're a citizen. I just have to, everybody that comes before me for a plea. Do you understand if you are not a United States citizen that taking a plea today shall subject you to deportation proceedings?
I am a citizen.
All right, not a problem. And I also must advise you that upon a third arrest after 2 convictions for theft, you may be charged with a felony petty theft and or receive jail or prison time. Do you understand?
Yes, I do.
All right, and sir, I also must, so how do you wish to plead? Guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, knowingly, and voluntarily given. And I also find there's a factual basis for this plea based on the probable cause affidavit. And I'll sentence you to an adjudication, time served, and no return to the Walmart and the police reports. And I'll give you the exact location. It's in Pembroke Pines. Oh, this is very tiny. It's Hold on, just give me 1 second. I have to zoom in really big because it's tiny. It's off of Southwest 10th Street in Pembroke Pines, I believe it. I can't read that, Mr. Linder.
You're on it?
Yes.
That might be.
That's it.
This is at a Walmart on 1800 South University Drive in Miramar.
Thank you. They give two different, why did they give?
I think you might have had the one, there was a felony petty theft, not in custody, he was arrested on at the same time.
Okay, thank you. All right, so don't return to that Walmart in the Miramar on 1800 South University Drive. Good luck to you, Mr. Myers. I'll convert your court cost of prosecution, and PD application fee to a civil lien since you have a state sentence. What that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you need to pay that off. Good luck to you, Mr. Myers.
Okay.
All right, so next is Mr. Blatch, whenever you guys have him.
No problem, John. Thank you.
He's on page 15 of the docket. My apologies. All right, Mr. Blatch, good morning, sir.
Good morning, Ms. Blackman.
It's Judge.
Judge.
Find probable cause for driving on a permanently revoked driver's license. Mr. Linder, first to you. All
Recommending an ROR to pretrial, Your Honor.
right, thank you.
No objection to that, Judge.
All right, Mr. Blatch, I'm going to release you to pretrial, but a condition of your pretrial based on the allegations that your driver's license has been revoked since 1994. You cannot drive while your case is pending. Do you understand?
Yes, ma'am. I can't drive, ma'am. I moved the car.
Don't talk about the fact
All right,
Mr. Blatch. Everything you're saying is being recorded and can be used against you. Do you understand?
All right, ma'am.
All right, so you cannot drive while your case is pending, but you're going to be released today, but you have to call in a pretrial release on Monday morning before 11 a.m. Do you understand?
Yes, ma'am.
All right, please give your phone number to pretrial before I continue with your provisional appointment.
954 954 446 3500.
Did you get that?
Will you be 3,500?
One more time, please.
954 446 3500.
3,500. All right, Ms. Edgley, does your office need to be provisionally appointed? All right, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Mr. Blatch. Call in on Monday, please.
Thank you, ma'am.
All right, not a problem. Let's go over to, I know that Paul Ryan has nobody this morning. Let's go over to main jail. And then we're going to start in order. All right, so I'll call Mr. Civil on page 15.
Mr. Civil, come on up, please.
Mr. Civil, good morning, sir. The court does find probable cause. Count 1, attempt murder in the first degree, premeditation. Count 2, armed burglary of a dwelling with a firearm, both as principles. I also make a finding of proof evident, presumption great, and I am going to hold you no bond based on these allegations of that the alleged victim was shot in his chest.
May I be heard as to proof evident presumption great, Judge?
You can, but I've already ruled. Go ahead.
Judge, I would just note that under this fact pattern, the individuals involved in this crime were wearing masks. There's no ballistics that have come back that have, matched any firearm to Mr. Civil. I would also note that Mr. Civil wasn't the alleged shooter. It's unclear exactly what, if he was in fact involved in this, what his role was under these circumstances, Judge. I would note that the state does have the burden of establishing proof evident presumption great, which is an extraordinarily high burden. And I would ask that the court would not find it just based upon the facts of this case.
All right, Mr. Under the state, wish to respond.
No, Your Honor, I rely upon the allegations in the arrest warrant affidavit.
All right, thank you. I do as well, which it clearly shows that there is a video, as well as it alleged that he was wearing the same exact clothing that he was at the hospital with the co-defendant, who was also shot allegedly by the victim, who fired back in self-defense after the victim was shot in the chest. The co-defendant is well known to the victim, and Mr. Civil was also there as a principal. So I've already made my ruling. You're going to be held no bond. You'll have to file a motion with your division judge in order to address that no bond hold on both of the counts. Sir, if your division judge does release you from custody, you cannot return to the victim's home. Do you understand?
Yes.
And even while you're in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means no phone calls, letters, no having a family member or friend send a message to the listed victim or any other means of communication. Do you understand?
Yes.
And you also cannot have any contact with the alleged co-defendant. Do you understand?
Yes.
Mr. Linder, is it a co-defendant in custody?
Not at this time, Your Honor.
Okay, so I'll just write no co-defendant contact. Sir, you also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, sir.
Judge, at this time also, Mr. Civil. Judge, at this time also, I'm going to be invoking his right to remain silent, not be questioned by law enforcement without first notifying his attorney of record, Judge.
All right, thank you, Mr. Romero. All right, good luck to you, sir. All right, we do have one Spanish interpreter case. So let's call Ms. Martin Lopez on page 3. Mr. Sinisi, good morning again, sir. Do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do. I give a certified Spanish court interpreter. Good morning, Your Honor.
All right, good morning again. This is on Ms. Martin Lopez. All right, ma'am, good morning. I do find probable cause for 3 counts of child neglect without great bodily harm.
Buenos días, señora. Sí, dictamino que existe motivo fundado para 3 cargos de negligencia de menor sin gran daño físico.
Sí. Mr. Linder, first to you.
Señor Linder, primero a usted.
Judge, I see no criminal history.
Su señor, no veo que haya antecedentes penales.
I'm recommending a $3,500 bond on each count, no victim contact.
Estoy recomendando una fianza de $3,500 para cada cargo y no tener contacto
Judge, I'm also requesting an order of no contact with minors.
También, su señoría, estoy peticionando una orden judicial de no tener contacto con menores de edad.
Considering, based on the allegations, one of the children involved in this matter was not her biological child.
Considerando y basado en las alegaciones, una de las criaturas involucradas en el caso no era su criatura biológica.
Your Honor, I'm basing these recommendations on the totality of the allegations and my concern for the welfare of the victims in this case. Nothing further.
Su señoría, estoy basando mis recomendaciones en la totalidad de las alegaciones del caso y también en la consideración del bienestar de las víctimas.
Thank you, Mr. Romero.
Gracias, señor Romero.
Judge, Ms. Martin Lopez has been residing in our community for the past 5 years.
Su señoría, la señora Martín López ha estado residiendo en nuestra comunidad los últimos 5 años.
She works taking care of her family. She cleans houses for a living, making approximately $300 a week.
Su señoría, ella trabaja cuidando a su familia y limpia casas, ganando aproximadamente $300 por semana.
She lives by herself in Hollywood, where she rents.
Vive sola en Hollywood, donde ella alquila.
My understanding, and more importantly, Judge, as I believe the state confirmed, she has no prior criminal record.
Mi entendimiento, y más importante, como confirma la Fiscalía, no tiene antecedentes penales.
Judge, based on her strong ties and her clean record, I'm going to be asking for the court to consider releasing her order pretrial.
Su señoría, basada en sus vínculos a la comunidad y sus antecedentes que están limpios, estaría peticionando que sea liberada bajo palabra.
If the court is not inclined, then I would ask for a monetary bond of $1,000 bond on each count.
Si no está inclinado a hacer eso, el tribunal estaría peticionando una fianza monetaria de $1,000 para cada cargo.
Now, Judge, my understanding, I believe the kids were removed. They were right now placed with their uncle.
Según tengo entendido, señoría, las criaturas fueron quitadas de su custodia, fueron ubicadas con su tío.
And I'm referring to as far as 2 of her own kids, Judge.
Y me estoy refiriendo, su señoría, a 2 de sus criaturas.
Judge, I'm going to be asking at this time for the court not to impose the special condition of no contact with the victim, which the state has asked for.
Su señoría, estoy peticionando en este momento que no imponga la condición especial que está pidiendo la Fiscalía de no tener contacto con la víctima.
However, if the court does impose it, I understand, but I'm going to be asking the court not to impose the condition of a blanket order of no contact with any minors.
Ahora, si lo impone, yo lo entiendo, su señoría, pero estaría peticionando que no imponga una orden judicial completa de no tener contacto con menores de edad.
I believe this is an isolated incident. By the court extending such a blanket order, that would even diminish her capacity to be employed as far as cleaning houses.
Entiendo que esto es un evento aislado y que si impone una orden completa del tribunal, eso disminuiría su capacidad o posibilidad de trabajar limpiando casas.
I'm also going to be asking to be provisionally appointed, Judge.
También su señoría voy a estar peticionando que sea nombrado provisionalmente.
Thank you.
Your Honor, if I may briefly.
Si puedo, brevemente.
No, it's my turn. Thank you.
No, es mi turno, gracias.
All right, I find it aggravating that the children, the 7-year-old specifically, told police that the mother leaves them home alone almost daily.
Encontré que era muy agravante que la criatura de 7 años le dijo a la policía que la madre los deja solas en la casa diariamente.
I also find it aggravating that there was a knife within arm's reach of the 3-year-old when the police arrived on scene.
También es agravante que había un cuchillo al alcance de la criatura de 3 años cuando arribó la policía.
And that the police noted that the home was in a poor condition.
Y notó la policía que la casa se encontraba en una condición pobre.
And there was no phone in the home for the children to call for help should an emergency have arisen.
Y no había un teléfono para que llamara para auxiliar a las criaturas si hubiese surgido algún tipo de emergencia.
Also, a neighbor, an adult, confirmed that the children were left home alone all the time and quite often by the mother.
También un vecino y un adulto confirmó que las criaturas son dejadas a solas todo el tiempo por la madre.
And the ages of the children were 7, 6, and 3 years old.
Y las edades de la criatura eran 7 años, 6 años y 3 años.
I am imposing a $10,000 bond on each of the counts.
Estoy imponiendo una fianza de $10,000 para cada cargo.
You cannot have any contact with any of the children, direct or indirect, or their caregivers. Do you understand?
Señora, usted entiende que no puede tener ningún tipo de contacto directo o indirecto con las criaturas o la gente que los cuidan.
She answered in the affirmative.
Ella respondió afirmativamente.
That means you cannot go by where the children live or go to school.
No puede pasar por donde ellos viven o donde van a la escuela.
You cannot call, text, email, social media, send letters.
No puede comunicarse por medio de llamadas, cartas, correos electrónicos, medios sociales.
Have a family member or friend send a message to the children.
No puede pedirle a un miembro de familia o un amigo que le mande mensajes a las criaturas.
Or any other means of communication that I have not said. Do you understand?
O cualquier otro medio de comunicación que yo no he anunciado. ¿Usted entiende eso? Yes.
Also, because this 6-year-old child is not your biological child, you cannot have any contact with any minors under the age of 18. Do you understand?
Entiende también que porque una de las criaturas tiene 6 años, no es su criatura biológica, usted no puede tener contacto con ninguna criatura menor de 18 años. ¿Entiende eso?
Sí.
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply.
Señor, voy a nombrar provisionalmente a la Oficina del Abogado Público para que la represente durante la pandemia. Una vez que concluya la pandemia, tiene que volver a reaplicar para su representación.
Is there anything else from either party that you still needed to address?
¿Algo más de alguna de las partes que tiene que abordarse?
No, Judge.
No, señora jueza.
Good luck to you, ma'am.
Suerte, señora. Your Honor, if the interpreter may bother the court, just the number of the case, Your Honor. Thank you so much.
Yes, it's 132101024. Not a bother, Mr. Shinesty. Thank you so much. Have a great weekend.
Thank you so much. Likewise, Your Honor. Thank you. Be safe.
You too. All right, so let's start on page 1. I know the listed victim is outside. All right, this is on Miss Candela. Is she at Maine?
She's here, present, approaching.
All right, thank you. All right, ma'am, good morning. I do find probable cause for touch or strike battery, domestic violence. Just give us 1 minute so we can talk to the listed victim if she wishes to be heard. All right, good morning, ma'am. How are you?
Good morning, Your Honor.
What is your name?
My name is Claudia Lopez.
And are you the listed victim in the case of Maria Candela?
Yes, ma'am. I'm the mother.
Okay, and are you here to see what happens, or did you want to tell me something?
I would like to tell you something.
Okay, so please raise your right hand for me, ma'am. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, I swear.
Okay, thank you. You can put your hand down and state your name again. I'm sorry, since you're now sworn.
Claudia Lopez.
All right, Ms. Lopez, it's my understanding that you were here without an attorney and you wanted to tell me something. So I needed to advise you that you previously spoke to law enforcement. So anything you say today can be used against you at a later date. Do you understand?
Yes, ma'am.
All right, thank you. What is it that you wanted to tell me, Ms. Lopez?
Your Honor, my daughter is mentally ill. She has been diagnosed with schizophrenia, bipolar. She has been baked up already 3 times. And all the psychiatrists suggest that she needs to go to an internship rehabilitation center. I beg you please to transfer her to a mental court. She is not able to be in society now.
Okay, thank you for that information. We do not have that. Does either party have any questions for Ms. Lopez today?
No, Judge.
No, Judge.
All right, thank you, Ms. Lopez, for that information. Are you here to ask me for contact with your daughter, or is there anything else that you wanted to ask me?
I'm sorry, I couldn't understand.
Does either party want to ask her any questions regarding contact before we move on, since she is here?
No.
No.
Okay. All right, not a problem. Thank you, Ms. Lopez. You can stay there, but while we finish with the case, okay?
Thank you very much.
Thank you for being here. All right, let me mute this. Mr. Linder, first to you, sir.
Your Honor, I can advise the court that there is no criminal history. However, there is a documented history in Broward of mental health matters. She went before Magistrate Laventure starting in 2019 for a petition of involuntary placement. There was a Baker Act order. Ultimately, the involuntary placement was denied in January of 2020, but it would appear that the file has been kept open because I'm showing that a petition and affidavit seeking an ex parte order for involuntary examination was filed with Magistrate Laventure mid-June of this year. So that would certainly seem to coincide with the information that the alleged victim is advised the court of. Your Honor, Your Honor, if there's somewhere else where she could stay, then I wouldn't have an objection to non-monetary release with the appropriate release conditions that could address any potential mental health issues. If there is no other place for her to stay at this time, Your Honor, I would be requesting a $1,500 bond. But also I'd ask no victim contact and mental health evaluation pre-trial with that she get a evaluation and follow all recommended treatment.
Thank you, Mr. Linder. Mr. Romero.
Judge, as you heard, Ms. Candela has no prior criminal record. My understanding, she's been residing in our community the majority of her life. My understanding in speaking with Ms. Candela, her intention is this fall to resume her studies at Florida International University, where she is pursuing a business administration degree. I did go over as far as some of the standard conditions on a domestic situation as far as no contact. She does understand that. She will be abiding by that. She's going to have to find a separate place where to live other than with the alleged victim. My understanding in reading between the lines and speaking with Ms. Candela, I do not believe her mother is going to be posting her monetary bond so she can get out. I'm going to be asking to be provisionally appointed. She will be appointed an attorney, and they will pursue any mental health concerns. Judge, at this time, based on her strong ties, her clean record, I'm going to be asking for the court to consider releasing her ROR to pretrial. If the court's not inclined, I'm going to be asking for a medical screening so she could be evaluated here at the jail and giving the appropriate medication, and a mental health screening at this time, Judge.
All right, thank you. All right, for some reason, Ms. Cooper, I don't know why the jail put a monetary amount on this domestic violence case because it needed to come before me for a bond. But if you could just inform whoever did that on these DV cases, they can be set prior to coming to magistrate. Okay, thank you. So I am going to, Mr. Linder, that was my question. You said she has a criminal history, but you didn't go into detail about it.
No, Your Honor, I said there was no criminal history, just the documented history of the issue before Magistrate Laventura.
Okay, thank you for that clarification. All right, so I do have serious mental health concerns based on what the listed victim came and testified today. However, based on that lack of criminal history, I am going to release her to pretrial release, but the condition of your pretrial release, Ms. Candela, you need to obtain a mental health evaluation by July 30th, 2021 and follow all recommendations. That's a condition of your release. Do you understand?
Yes, ma'am.
All right, that means that you're going to get out today, but you have to call into pretrial release before 11 a.m. on Monday. So please give your phone number to pretrial so they have it on file.
Yes, ma'am. 954 649419.
We couldn't hear you. It broke up after 954.
954-864-9419.
Did you get it? Yeah. All right, ma'am. In addition to the mental health evaluation by July 30th of this year and following all recommendations, you cannot have any contact, direct or indirect, with a listed victim, your mother, while this case is pending. Do you understand?
Yes, ma'am.
That means not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, or ammunition while this case is pending based on the domestic violence nature. Do you understand?
Yes, ma'am.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply to make sure that they keep representing you. Is there anything else that we need to address on her case?
No, considering at this time that the court released her on pretrial, I'm not going to be ordering or asking for a mental health screening and medical screening here at the jail.
All right, not a problem. Good luck to you, ma'am. Good luck to you, Ms. Lopez. Thank you for being here. We're going to try to see if we can get her some help, okay? All right, not a problem. Let's call Ms. Perry next on page 1.
Hi, good morning.
All right, good morning, Ms. Perry. I do find probable cause for touch or strike battery, domestic violence, and trespassing an occupied structure or actually dwelling. Mr. Linder, first to you.
Recommending R1 to pretrial, no victim contact, no return.
Okay, the alcohol influence box was also checked off, so I'm taking that into consideration. Ms. Edgley, to you, ma'am.
Judge, Ms. Perry has been a Broward County resident for 2 years. She has family support in the community. She's not able to afford bond, so no objection to releasing her to pretrial release, Judge.
All right, I am going to release you to pretrial release, Ms. Perry, but you're going to be randomly screened for drugs and alcohol, which means that you cannot use drugs and alcohol while your case is pending. Do you understand?
Yes, I have a question. My mom put her hands on me and she was drunk.
Ms. Perry, don't discuss the facts of the case. If you need to speak with me, we can speak privately.
I don't want to deal with it. What do I need to do to like not?
Ms. Perry, again, we can discuss it privately.
Okay.
All right, it sounds like you're trying to talk about the facts of your case, Ms. Perry. That's not in your best interest. Everything you're saying is being recorded and can and will be used against you, okay?
Okay.
All right, so I am going to release you to pretrial release, which means you're going to get out today, but you have to call into pretrial before 11 a.m. on Monday. So please give your phone number to pretrial before I continue with my orders.
954-479-1276.
Did you get that, Ms. Brown?
I did not get the last one.
Last 4 digits, please.
1276.
1276. All right, Ms. Perry, you cannot return to the listed victim's home, your mother's home. Do you understand?
Yeah.
You also cannot contact her direct or indirect, meaning not only can you not go by where she lives, if she works, you can't go there. You can't call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication I have not said. Do you understand?
Yeah.
You cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yeah.
And again, you're also going to be randomly screened for drugs and alcohol, so you cannot use either of them. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Ms. Perry. Once COVID is over, if this case is still pending, you will need to reapply, ma'am. Anything else on her case that we need to address?
No, Judge.
All right, good luck to you, Ms. Perry.
Thank you.
All right, next is Ms. Williams on page 1.
Williams.
All right, thank you. Ms. Williams, good morning, ma'am.
Hi.
I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, hold on, let me mute this. And now to you, sir.
Judge, I'm recommending a $1,500 bond, no victim contact. It's based on the allegations. Also, Ms. Williams has a pending possession of alprazolam from 2020. I'm showing a arrest for felony battery against a victim over the age of 65 against a different alleged victim that was dropped. Judge,
You know what year? Sorry.
2020.
Okay, thank you.
Showing 2019 unlawful use of false name ID, prostitution, 2 cases in 2019, 1 in 2018, paraphernalia 2018, possession of cocaine 2017, another possession of cocaine 2017. There was 2002, 2 counts of battery, nothing further.
Okay, thank you. Ms. Edgley?
Judge, Ms. Williams has been a Broward County resident for 40 years. Currently, she's unemployed. Unfortunately, she used to work at a restaurant. She's seeking employment. She does have a place to stay away from the victim. And unfortunately, Judge, she's not able to afford any bond. I don't believe she's in any serious criminal history. And so I would ask Judge that she would be released on a pretrial release on her own recognizance.
All right, thank you. Ms. Williams, you have 2 previous battery convictions, so please know that this case could be filed as a felony battery should the state choose to do so. I just need to advise you of that. Based on that and the pending alprazolam case, I am going to set your bond in the amount of $1,000. Ms. Williams, you cannot have any contact with the listed victim, direct or indirect, even while you are in custody. Do you understand?
I do.
Sorry, you need to speak a little louder. Is that
I understand? I do.
all right? That means that you cannot live with him, call him, text him, email, media, send letters, or any other means of communications that I have not said. Do you understand?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
I do.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Ms. Williams. Once COVID is over, if this case is still pending, you will need to reapply to make sure that they keep representing you. Anything else on her case?
No, Judge.
Good luck, ma'am. Next is Ms. Toro on page 2.
No problem, John.
All right, thank you. Ms. Toro, good morning, ma'am.
Good morning, Your Honor.
I do find probable cause for touch or strike battery. Mr. Linder, to you.
Recommending an ROR to pretrial with random testing, no victim contact. She had battery arrests in 02 and 95. They were dropped to DUI in 96. Nothing further.
96 DUI, 95, the battery was dropped.
Yes, Judge.
Okay, thank you. Ms. Edgley?
Judge, Ms. Toro has been a resident of Broward County her entire life. She does live at the location. It is her apartment in her name. And so she would like to return there to reside. She currently is not working. She's actively seeking work and applying for jobs and waiting to hear back, Judge. Unfortunately, she's unable to afford any bond. It's my understanding she doesn't have serious priors, no history of failure to appear. And I would ask that she would be released on her own recognizance to pretrial release.
All right, thank you. That was the state's recommendation.
Sorry, Judge.
That's okay. All right, Ms. Toro, I am going to release you to pretrial release. However, based on both the alcohol and drug influence spots being checked off, you are going to be not only but randomly screened for drugs and alcohol, which means that you cannot use drugs or alcohol while your case is pending. Do you understand?
Yes. Yes, Your Honor.
All right, you also cannot have any contact, direct or indirect, with the listed victim. That means that you with him, call him, text him, email, social media, or have a family member or friend send a message to him, or any other means of communication that I have not said. Do you understand?
Yes, Your Honor. Am I allowed to return to my resident? He's not a resident there. He was just there when it happened, and he's I'm afraid he's in my house
Ms.
robbing.
Toro, I wouldn't discuss the facts of the case.
Am I
So, Ms.
allowed-
Toro, you can talk to your attorney about any civil remedies you have with regards to getting him out of your home. I cannot give you any legal advice about that, but what I can tell you is the only thing I've advised you of and ordered you of is that you cannot live with him. You would need to talk to your attorney about civil remedies to get him out if he's not on the lease, okay?
It's not, all right.
All right, so that's why I'm provisionally appointing the public defender's office to represent you during the pandemic. Once COVID's over, you'll need to reapply if this case is still pending. Be in touch with them so that they can give you legal advice on what to do with regards to that living situation. But you cannot possess any weapons during while this case is pending, including mace, based on the allegations. Do you understand?
Yes.
All right, and anything else on her case that we need to address?
No, Judge.
Sorry, please provide your phone number to pretrial. I forgot to ask you for that.
813-602-4117.
Did you get that? 4117. I don't know. One more time, please.
Yes, 813-602-4117.
Thank you. All right, thank you, ma'am. So you're going to be released today, but you have to call in before 11 a.m. on Monday, okay?
Okay.
All right, good luck to you, ma'am. All right, next on page 3 is Ms. Hernandez.
And Judge, she respectfully requests to waive her appearance today.
Oh, okay, thank you. No problem. All right, so let's go forward to Ms. Hernandez. Okay, thank you. So waive her presence. Okay, so I do find probable cause for possession of heroin, possession of fentanyl, drug paraphernalia, and her pretrial warrant that she's being held no bond on. I will leave the bonds in place on 1 and 2, ROR on 3, leave the no bond hold in place. She'll have to go before her division judge for relief. And Ms. Edgley, are you asking to be provisionally appointed?
Yes, Judge.
And then I'll provisionally appoint the public defender's office to represent her during the pandemic. Anything else that we need to address on her case?
No, Judge.
Okay, thank you. That brings us to Ms. Bacon on page 3. All right, thank you, Ms. Bacon. Good morning, ma'am.
I'm sorry. On Ms. Hernandez, Lopez, she's not gonna get the credit for the police because she's on this no bond.
I mean, if Miss Edgley wants the bond back on, that's
We
fine. But I
can
don't,
keep the $100 bond in place,
I don't think
Judge.
she's going.
Okay, thank you. So let me go back and write the $100 bond back in. Thank you, Ms. Cooper. I'll just initial it. All right, thank you for that. Okay. All right, so this is back on Ms. Bacon. Thank you for your patience. I find probable cause for delivery of cocaine. It notes in the police reports, Mr. Linder, that she's on felony probation. Can you tell me?
One moment, Your Honor.
Ms. Bacon, please don't discuss the facts of your case, okay?
Respectfully, Judge, I'm not showing that Ms. Bacon is on probation anyway.
Okay, thank you. So does she have any priors?
She does, Your Honor. 2016 possession of cocaine. There was a violation of probation in that matter. A couple prostitution cases in 2019.
Okay, thank you. Ms. Edgley?
Judge, Ms. Bacon has resided in Hollywood, Florida for the last 6 years. She intends on residing with her mother back in Hollywood, Florida. Excuse me, she intends on going back to Hollywood, Florida, or residing with her mother who lives, I believe, in Sunrise. Judge, she's currently unemployed. She's not able to post any bond. I'm requesting that she be released on a standard pretrial release or release on her own recognizance in the alternative.
All right, based on the allegations of delivery of drugs, I'm not going to do that. I will leave the bond in place, finding it that she's a danger to the community by delivering drugs within our community. I'll leave the standard $2,500 bond in place and provisionally appoint the Office of the Public Defender to represent you during the pandemic, Ms. Bacon. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, ma'am. Next is Ms. Davis on page 4.
Maine approaching, Judge.
All right, thank you. All right, Ms. Davis, good morning, ma'am. I do find probable cause for possession of cocaine and drug paraphernalia. Mr. Linder, first to you.
Judge, I'm recommending an ROR to pretrial with random testing on the cocaine charge.
Okay, thank you. Mr. Romero?
No objection, Judge. This has to be provisionally appointed. I know she does not have a number. I did advise her when she calls into pretrial for her to go ahead and give her contact information or contact phone number.
No problem. Ms. Davis, you're going to be released today, but you have to call into pretrial release before 11 a.m. on Monday. I know that you have indicated you don't have a number right now, but when you do call in on Monday before 11, just let them know a phone number, a name of someone that they can reach you, and an address that they can reach you at, okay?
Okay.
You're also going to be randomly screened for drugs and alcohol, so that means you cannot use drugs and you cannot use alcohol while your case is pending, understood? And if there's an initial positive screen for drugs, that's your baseline. On later testing, if the levels don't go down, but instead stay the same, get higher, or there's a new drug or alcohol introduced, you could be violated. Do you understand? Sorry, was that a yes?
Yes.
All right. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Ms. Davis. Please call in on Monday.
That's just the phone number you call in on Monday, okay? Good luck, man. Go.
All right, next is Ms. Joseph on page 4.
Ms. Joseph, come on up. She's here, present, Judge of Maine.
Okay, thank you. Good morning, Ms. Joseph. I do find probable cause for grand theft auto, resisting without violence, fleeing or eluding officers at high speed, operating without a valid driver's license, and petty theft, second degree, third or subsequent offense. Mr. Linder, first to you.
Judge, recommending a $5,000 bond on count 3, pretrial release GPS monitor. No return, no victim contact. I do believe she is a flight risk based on the allegations and the driving pattern in the report, specifically, but not limited to, the allegation that she drove the wrong way on Sunrise Boulevard. Additionally, as far as history, 2019, dealing in stolen property, sentenced to a year probation as a habitual offender on April 1st of last year. Felony theft, 2019, grand theft auto, 2018 with the VOP, 18-month state prison. Felony theft 2018, 12.5 months state prison. Theft 2017, criminal mischief 2014, theft and resisting a merchant 2014, grand theft and resisting a merchant 2014, with a violation of probation 42-month state prison. 2014, possession of cocaine, attempted tampering with evidence, carrying concealed weapon, 2 years state prison. 2014, fleeing and eluding, petty theft, VOP, 42-month state prison. Grand theft auto 2013 with the VOP, 42-month state prison. Judge, there are additional priors, but I will stop there.
Okay, thank you. Mr. Romero.
Judge, and speaking of Ms. Joseph, she's been residing in our community her whole entire life. At this time, she advised me she is not working. She's looking for employment. However, she does have a place to stay. She lives in Lauderhill with her mother, where they rent, they do not own. She's been residing there for a number of years. Her mother's the only person that can post her monetary bond, but her mother's an hourly employee, is not going to be able to afford the $5,000 bond on count 3, which the state has asked for, Judge. I was going to be recommending a $1,000 bond on count 3. On the misdemeanor offenses, specifically counts 2 and 4, I was going to be recommending an ROR. Judge, at this time, I know she's looking for work, so I wouldn't object if the court wanted to do standard pretrial as opposed to with the monitor.
All right, thank you. Ms. Joseph, based on that very lengthy history, you being declared a habitual felony offender previously, as previously sentenced, I am going to impose a $5,000 bond on count 3, also deeming you a flight risk based on these allegations, the alleged driving pattern of driving the wrong way and driving without a valid driver's license while doing so allegedly. Once you post bond, you're going to be supervised by pretrial release with a GPS monitor, ma'am. That means that you can go to work or look for work with a pre-approved schedule, and then you can be at home while your case is pending. You cannot drive without a valid driver's license. Do you understand?
She answered in the affirmative.
You also cannot return to the incident location or the Home Depot in the police reports. Do you understand?
Yes.
And you cannot have any contact with the listed victim, direct or indirect, meaning you cannot call, text, email, social media, send letters, or have a family member or friend send a message, or any other means of communication that I have not said. Do you understand? And on counts 4 and 4, I will ROR the resisting without, I'll also ROR, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, ma'am.
Judge, I'm sorry.
Yes,
You said count 2, you're taking out the bond.
yes, count 2 and 4, the misdemeanor offenses I ROR.
Okay, but you couldn't take some pretrial release here.
Yes, the whole case.
Okay, thank you.
Yep, 3 is 5,000. All right, thank you. Next is Miss Bend on page 5, who's waived her presence.
Judge,
All right, thank you. I do find probable cause for her out-of-state hold from Texas for engaging in organized crime. She's going to have to go before extradition court next Tuesday. Anything else on her case? Okay, thank you. Next on page 6, Mr. Molina.
he's here present, Judge, and May.
Okay, thank you. Good morning, sir. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, let me turn this down for.
Judge, I see no history. I'm recommending $1,000 bond, no victim contact. It's based on the level of violence, the bruising and scratches the victim suffered. Also, I'm concerned based on the allegation that she felt the need to run out of the home and go to a neighbor's home to seek help.
Okay, Mr. Romero.
Judge, I spoke Mr. Molina. I did advise him the purpose of today. It's not an evidentiary hearing. You'll have his day to fight these allegations. I have noticed he does have several wounds also on his body, and he can present that information to his attorney to present to the case filer. This maybe for our defense position would be a mutual combat situation. Having said that, Judge, he's been residing in South Florida for 18 years. He is working. He does live with the alleged victim. I did advise him as far as the no contact, he's going to find a separate place to live. Judge, this is the first time he's ever been arrested in his life. He's a registered voter. Based on this misdemeanor offense, Judge, his lack of prior strong ties, I was going to be requesting an ROR pretrial on Mr. Molina's behalf, Judge.
All right, I'll set bond in the amount of $500 so Mr. Molina, the conditions of your bond, even while you're in custody, sir, you cannot have any contact with the listed victim. Do you understand?
Yes.
That means that not once you get out, you can't live with her, but also in and out of custody, you can't call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes.
Based on domestic violence nature, sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
Mr. Romero, does your office need to be provisionally appointed?
Yes, Judge, and I'm also going to be requesting a property order.
Okay, I'll sign that property order. Did you want a phone order based on what you told me? Photo order?
Judge, I'm going to be requesting a phone order.
Phone, property, no photo order?
No, my understanding is when he gets out, he's going to go ahead and take pictures of his own injuries.
All right, no problem. Okay, so and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure that they keep representing you. Good luck to you, sir. Next is Mr. Havania on page 7.
Coaching Judge.
The DV paperwork, Raj, is not here. The DV no contact for this case. Can you please prepare one?
Okay.
Okay, thank you. All right, Mr. Linder, it looks like it's alleged that the listed victim struck him first with a diaper bag. At this point, I don't find PC for battery. I would, in the alternative, find probable cause for disorderly conduct.
Your Honor, I would just argue, and I understand the court's rule, but for the record, even for self-defense, it has to be commensurate. And Your Honor, the allegation is that she hit him with a bag with a diaper in it. His response was to punch her in the left eye with a closed fist, causing injury to her eye and cheek, and which caused bruising to her face. I would also note, according to the PC affidavit, the alleged victim in this case, from what I can tell, is 5'1", 5'2", between 170 and 175 pounds. where according to the booking sheet, Mr. Havania is 5'8", 200 pounds. I think the court can find that his response to being hit with a bag with a diaper in it was not necessary for self-defense, Your Honor.
All right, thank you. Ms. Edgley or Mr. Romero, anything to add?
Judge, I would just respond by stating that I don't think the probable cause affidavit indicated where on his body he was hit with the bag containing the diaper, how much force was used. Obviously, when somebody is hit, there's a reaction that comes in an effort to protect oneself. And so I would ask that the court would not find probable cause for battery and would consider the facts and circumstances when setting bond.
All right, thank you. I find probable cause for disorderly conduct over the state's objection.
Your Honor, I see no history, but based on the level of violence that's alleged that he punched the victim in the face, causing bruising, I'm asking for a $1,000 bond and no victim contact.
Okay, thank you. Mr. Romero?
Judge, in speaking with this gentleman, this is the first time he's ever been arrested in his life. Now, he does live with the victim. He's going to have to find a separate place to live in order to abide by the court's no contact order. In speaking to him, there's probably some things that have been omitted from the PC affidavit. There was more than a diaper. I clearly observed bite wounds on his left arm. So there's other marks that were left by the alleged victim. Having said that, Judge, because he has no priors, because this is a disorderly conduct, or the court found probable cause for disorderly conduct, I believe the most important thing would be a no contact order. He will be abiding by that. I'm going to be asking for an ROR, Mr. Wahabiania's behalf. If not, I'm going to be asking for a $100 bond on his behalf, Judge.
I can release him to pretrial, or I can release him to with a $500 bond. It's up to you what he wants to do.
Judge, $500.
All right, sir, I'm going to set your bond in the amount of $500. You cannot have any contact with the listed victim, direct or indirect. I understand what I've just said before, that there was an alleged touching without your consent first, but you cannot contact her, direct or indirect, meaning you cannot live with her, call her, text her, email, social media, have a family member or friend send a message to her for you. Do you understand?
Yes.
All right, and I will provision, does your office need to be appointed?
Yes, Judge.
All right, sorry about that. And I will provisionally appoint the public defender's office to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else on his case that we need to address?
No, Judge.
All right, sir, good luck to you. All right, next is Mr. Malik on page 8.
Mr. Malik is present on my left, Judge.
All right, thank you. Good morning, sir. I do find probable cause for touch or strike battery, domestic violence, and tampering in misdemeanor proceedings. Mr. Linder, first to you.
I believe the alleged victim, Ms. Malik, is present, Your Honor.
Is she on the Zoom? Okay, give me 1 minute. All right, thank you. All right, Ms. Malik, good morning, ma'am. You are the listed victim. Are you here to ask me to tell me something, or are you here to just see what happens?
Both.
Okay, so please raise your right hand for me, ma'am. Swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
All right, now that you're sworn in, ma'am, please state your name for the record.
Nurunisa Malik.
All right, ma'am, you are the listed victim and you are here without an attorney. So I need to advise you that anything you say today can be used against you at a later date. Do you understand?
Yes.
All right, what is it that you wanted to tell me, ma'am?
I need time to transition. So if I can have no contact with him for a couple of weeks, because I have a old 89-year-old mother who can be dead in maybe a couple of days because she's having severe CKD problem. And yesterday, since she saw all of the things at home, it has traumatized her. So if I can have a couple of weeks that he doesn't contact or he doesn't come, that'll be greatly appreciated.
All right, thank you for letting me know that, Mrs. Malik. Any questions for the listed victim while she's on Zoom?
Yes, Your Honor.
All right, thank you, ma'am, for being here. If there's nothing else, I'm going to mute you, but you can keep your camera on for his proceedings, okay?
Okay.
right, thank you. All right, Mr. Linder, first to you.
Judge, I'm recommending, well, I don't see a history. I'm recommending a $2,500 bond on each count, no victim contact. Your Honor could see the injury the victim suffered on the Zoom conference that's described in the report. Based on the level of violence and his actions to try to prevent Ms. Malik from contacting law enforcement, I think these bonds are appropriate to ensure the safety of the alleged victim.
All right, thank you. I do know that she still has a black eye while appearing on Zoom today. All right, Mr. Romero, next to you.
Judge, Mr. Malik has no prior criminal record. My understanding, he's been residing in South Florida now for 3.5 years. He does understand the significance of the no contact order, direct or indirect. He will be finding a separate place where to reside. Judge, I know the court, I observed, I guess, the physical injuries of the victim. Also, the record reflect that I have observed the physical injuries of the alleged defendant, both on the neck and on the left arm as well. Based on his lack of criminal priors, I was going to be requesting a $1,000 bond on each count and to be provisionally appointed on his case.
Okay, thank you. I also know that the alcohol and drug boxes, influence boxes are checked off. So he's going to be supervised by pretrial release once he posts a bond. So on count one, I will set bond in the amount of $1,000. On count two, $2,000. Once you post your bond, sir, you're going to be supervised by pretrial release. So please give your phone number to pretrial before my orders.
305-898-3730.
What were the first three?
305.
305. Okay. Go ahead.
3730.
Did you get that, Ms. Brown? Yes. All right, sir. You can't use any drugs or alcohol while your case is pending because you are going to be randomly screened for drugs and alcohol. Do you understand?
I do.
You also cannot have any contact, direct or indirect, with your wife. Do you understand?
I do, ma'am. My father, 94-year-old, lives at that place. I need to have some sort of a contact. Please allow me, otherwise he's going to pass away.
No, sir, for now she has asked me and I'm ordering that you cannot have any contact with her, direct or indirect. Do you understand?
I understand that, ma'am, but could you make some provision that at least I could see my dad?
Anywhere but at the home, Mr. Malik, you cannot, because you cannot contact her. If there's other family members at the home that can coordinate a contact with you for your father, I will make an exception for third-party contact with regards to seeing your father, but you cannot contact Mrs. Malik to make those arrangements. Do you understand?
I understand, not Mrs. Malik, but my dad, he cannot move anywhere. He doesn't have any legs left anymore.
So you can have third-party contact with regards to seeing your dad. Mrs. Malik cannot be at the home when you go and visit your dad. Do you understand?
I understand.
All right, so that means that no phone calls, text messages, emails, social media, family members or friends to send a message to her or any other means of communications that I have not said. Do you understand?
I understand.
And you cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
I understand, ma'am. Can I pick up my stuff from there?
Okay, I will give you a one-time allowance with law enforcement for the city within which you live. It looks like it's Davie, so you have to go to the Davie Police Department with this order, which will give you a one-time allowance to go to the home to get your belongings so you can live separately. And that's one time after court, but you cannot contact Mrs. Malik to let her know you're coming, and you must be accompanied by police or you will be in violation of this court's orders. Do you understand?
I understand that, ma'am.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else in Mr. Malik's case that we need to address?
No, Judge.
All right, good luck to you, sir. Okay, I'm just adding that exception into the order regarding his father. All right, good luck to you, Mrs. Malik. All right, so next is Mr. Velez on page 8.
Judge, he needs to refuse. I'm asking for it to be reset for tomorrow.
Okay, thank you. Over defense's objection, he's being held no bond. These are crimes of violence. We're proceeding. Thank you for that. All right, I do find probable cause counts 1 and 2, aggravated battery offender knew or should have known victim was pregnant, a false imprisonment of an adult, the alleged pregnant female. Count 3 is a violation of probation for an armed burglary dwelling. He's being held no bond on, that I cannot change. It's a signed warrant. So Mr. Linder, first.
Your Honor, I believe the alleged victim, Ms. Rodriguez, is present.
Okay, give me 1 minute. Let's pull up. All right, Ms. Rodriguez, I've just sent you a request to start your camera, ma'am, and unmute yourself.
Hello.
All right, Ms. Rodriguez, good morning, ma'am.
Good morning.
You are the listed victim, correct?
Yes.
And did you wish to tell me something, or are you just here to see what happens?
Both.
Okay, please raise your right hand for me, ma'am. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down and please state your name for the record.
Franceli Rodriguez.
All right, Ms. Rodriguez, what is it that you wanted to tell me?
I just wanted to state that I wrote an affidavit stating that I was acting out of my emotions and exaggerated a lot of the facts. I was just angry and pregnant. We were arguing, but it never got physical.
Okay, does any party have any questions for her?
I do, Your Honor.
Okay, go ahead.
Mrs. Rodriguez, do you recall giving a sworn statement on February 3rd of this year to Officer Jackson?
Yes, I recall that.
You do?
Mm-hmm.
Do you remember?
Is that a yes, ma'am? With the court report?
No, like yes.
You have to say yes or no.
Okay, sorry. Yes.
And do you recall telling the officer that you had the date of this incident, you had a conversation with a friend of Mr. Velez's named Angel?
Yes.
Okay. And do you recall Angel telling you, you guys argue like this and you never leave him?
Yes, but we don't argue. It never was physical.
Ma'am, I'm just asking if you recall.
Yes.
Thank you. Then do you recall telling Officer Jackson after that the reason you don't leave him is because nobody ever actually helps you when you're trying to leave him in moments like this when you're scared for your life?
I did.
Jackson that?
I did say that, but I did.
Okay.
I'm no longer within his proximity. So that statement is false.
Do you recall, one moment, ma'am. Do you recall telling law enforcement that Angel's girlfriend was also at the home?
She wasn't at the home. We met up with her later.
Do you recall telling Officer Jackson that you had a conversation with his girlfriend?
We met that day and we spoke, but not about any of my arguments with Joel.
Do you recall this woman starting a conversation with you because she advised she was a victim of domestic violence for over 5 years and she knew what it looked like when someone's a victim of domestic violence?
No.
You don't recall that? So I imagine you wouldn't recall telling Officer Jackson that you told this woman that, no, you're not okay, you're trying to leave?
No.
Do you recall telling Officer Jackson about the recent acts of violence that Mr. Velez committed against you prior to this incident?
No.
Okay, so I imagine you do not recall telling Officer Jackson that there were, one moment. Incidents on January 23rd of this year and January 23rd of this year and February 3rd of this year, where he committed acts of violence against you?
No, he was nowhere even near me on February 3rd.
Do you recall telling Officer do you recall telling Officer Jackson or an Officer McClendon that Mr. Velez has physically assaulted you many times in the state of Georgia, but you never notified the police?
No, again, that was me acting out of emotions. I was upset with him over cheating.
So you don't recall saying that, or you do recall saying that?
I recall saying it. I just,
Okay.
It's not true.
Okay.
That's why I made an affidavit saying I wish to not testify and that I acted out of emotion and that I don't want to be part of the case. I don't want to testify.
And is it also true that you took photographs of your injuries that you suffered as a result of this incident with Mr. Velez?
Those were my dogs. I'm on blood thinners. So when I play with them, they bruise me pretty easily. Like I have new bruises all the time. And I just said that to get him in trouble.
Your Honor, I have nothing further.
Sorry, Mr. Linder.
I have no further questions, Your Honor.
Okay, thank you. Mr. Romero, any follow-up questions?
Just brief, Judge. Ms. Rodriguez, at this time under oath, you said at this time, your testimony before the court today you're thinking clearly. Is that correct?
Yes.
And on your previous occasions when you spoke to law enforcement, according to what you're saying, you were not clearly thinking at that time. Is that correct?
No, I was just angry, sad, upset, all of the above.
Thank you, ma'am. No further questions.
Judge, if I may inquire briefly.
I just have one question for her. How many weeks pregnant were you on February 2021? February 25th, 2021.
In February, at the time when I wrote the statement, I was 8 weeks pregnant. I am now 8 months tomorrow.
Okay, thank you, ma'am. Go ahead, Ms. Edgley.
So just to be clear, you were never held against your will, is that correct?
No.
No, I'm sorry, can you say that again?
No.
You were not held against your will?
No.
Okay, and the injuries that you suffered were not caused by Mr. Velez?
No.
They were caused by your dogs, you said?
Yes, playing rough. They're big dogs.
Okay, thank you, ma'am. No further questions.
All right, thank you. Mr. Linder, any follow-up based on that?
No, Judge.
All right, thank you, ma'am. Thank you for being here. I'm going to mute you at this time, but you can leave your camera on because we're addressing your case. All right, Mr. Linder, first to you, sir.
Thank you, Judge. Your Honor, I'm asking for a $25,000 bond on each count.
Sorry, how much?
$25,000.
Okay.
Pretrial release of the GPS monitor, level 2. No victim contact. Judge, it's based on the level of violence alleged in this report. Also, which Ms. Rodriguez confirmed in her 16-page sworn statement that she gave to law enforcement the evening after the incident occurred. Your Honor, I'm also noting that her sworn testimony that to law enforcement that there's been prior violence in a relationship, specifically 3 incidents within a 1-month period. Also, I would note his criminal history, Your Honor. He's on probation for the armed burglary dwelling, where he was sentenced to 10 years in state prison, to be followed by 5-year state prison. Just one moment. I just want to see when he was released from state prison.
You mean probation? 10.
Yeah, 5 years probation. Yes, thank you, Judge. One moment. Yeah, so he was released from state prison in May of 2020. So he wasn't even out a year when this alleged incident occurred. Your Honor, also he had a 2011 strong arm robbery where he was sentenced to 10 years in Florida State Prison. Nothing further.
Thank you, Mr. Romero.
Judge, before Mr. Romero provides information for bond, if I may just make argument for PC. Judge, I would ask that the court, thank you, Judge. I would ask that the court would find no probable cause for the false imprisonment count 2 and also count 1, the aggravated battery. We heard from the illicit victim today. She said that she was never held against her will. She also testified that she wasn't injured by Mr. Velez. All the injuries were in fact caused by her very large dogs from playing rough with them. So I would ask that the court find no probable cause on these 2 counts.
Okay, thank you. I maintain my finding of probable cause. Her statement given to police was at or near the time of incident, which is more reliable than today, 5 months after the incident date. So thank you. All right, anything else?
Judge, as the court is aware, Mr. Velez, I haven't had an opportunity to speak to him. I don't know as to his financial resources. All I could say at this time for mitigation purposes, you have heard direct testimony from the alleged victim herself. At this time, Judge, I can't imagine how far this case is going to go. The weakness of the state's case, I'm asking for the court to consider an ROR 1 and 2. I do understand he's going to be held no bond on count 3, but that is the defense request at this time, Judge.
All right, thank you. He is facing life in prison on his violation of probation, and the state doesn't need to file charges in order for the court to impose that life imprisonment if the court finds by the standard that he has intentionally violated the terms of his probation. Based on her statement as well, she advised police that he was using methamphetamine, which is again a violation of his probation. So based on all of that, in addition to the level of violence, I am going to set bond at $25,000 on 1 and 2, no bond on 3. Pretrial release level 1 with a GPS, strict house lockdown should he post bond. I'm aware he's from Georgia, but he's going to have to find accommodations in Florida to remain here if he is released from custody by his division judge. Random screens for drugs and alcohol at least 2 times per week. No drugs and alcohol. No victim contact, direct or indirect, Ms. Rodriguez, meaning he cannot contact you by phone, letter, family or friend, or any other means of communication that I have not said, ma'am. He also cannot possess any firearms, weapons, or ammunition while his case is pregnant, based on the domestic violence nature. I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Once COVID is over, he's going to need to reapply to make sure that they keep representing him. Good luck to you, Ms. Rodriguez. Thank you for being here. Next is Mr. Tolbert on page 8. I need the DV form on that one too, please, Raj.
He's approaching, Judge. He's here on my left.
And the next one too, Nicolosi. That doesn't have one for some reason, those two. All right.
Your Honor, I'm just going to let the court know I was going to take down put the name on a post-it and provide it to the clerk so it could be put on the no contact order.
Okay, thank you. Yes, I have them, the findings. All right, thank you. Does he have a prior battery conviction, Mr. Linder, before we move on? This is on Mr. Tolbert.
Yes, Your Honor, one moment.
Okay.
Yes, Your Honor, I'm showing he was convicted of, or he had a battery on a law enforcement officer. In 2004, it was a 2003 offense.
Okay, thank you. All right, so I do find probable cause for count 1 is a capias for battery on a person 65 years or older. You're being held no bond on that. You're going to have to see your division judge. On count 2, I do find probable cause for battery, second or subsequent offense based on priors, that prior battery on an officer that was referenced by Mr. Linder from the state. Mr. Linder, any other priors in that battery deal and the state's recommendation, please?
Judge, I'm recommending a $7,500 bond, pretrial release of the GPS monitor, level 2, no victim contact, no weapons. It's based on the level of violence, the alleged threat to kill, Your Honor, noting that at the time of this incident, he had a pending battery on a victim over 65 that he failed to appear in court on. I can advise the court that 2 cases involved 2 different alleged victims. He was also arrested in 2018 for felony battery against a victim over the age of 65. That was dropped. He was arrested for battery in 05. That was dropped. He was investigated in 07 for a not in custody DV battery. That ended up not being filed. He had the battery on a law enforcement officer that I mentioned. That there was also a resisting with violence charge. There was an additionally a charge of aggravated battery, but that was dropped. And lastly, he had a grand theft auto in 95. Nothing further.
Thank you, Mr. Romero.
Judge, I do understand Mr. Tolbert's being held no bond on count 1. He's going to have to go in front of his division judge. He's not working at this time. No one's going to be able to post a $7,500 bond. I'm asking you to take his financial resources into account in determining reasonable release conditions on count 2. But more importantly, I'm going to be asking to be provisionally appointed in a medical screening order, Judge.
All right, I'll sign that medical screen order. I'll also provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Tolbert. Once COVID is over, you will need to reapply if these charges are still pending. You cannot have any contact, direct or indirect, with the listed victim, even while you are in custody. Do you understand?
Yes, ma'am.
That means you cannot call her, send letters, have a family member or friend send a message, or any other means of communication. Do you understand? If your division judge does give you release on the Capias case, you cannot go where she's living, you cannot go where she's working, you cannot call her, text her, email, social media, or any other means of communication. Do you understand?
He answered in the affirmative.
Okay, thank you. And you also cannot possess any firearms, weapons, or ammunition while your case is pending, sir. Do you understand? All right, based on the allegations that he allegedly pulled a firearm out and pointed at the victim and threatened to kill her, I am going to set bond on that count, battery, second or subsequent offense, in addition to battering her, at $7,500. Once you post bond, you're going to be supervised by pretrial release, level 1 with a GPS, strict house lockdown, should your division judge release you from your no bond hold. And I will send that med screen order. Good luck to you, Mr. Tolbert. Next is Mr. Nicolosi on page 9.
Judge, just to refresh the court's recollection, he advised me he has private counsel, Mr. Barry Roderman. Mr. Nicolosi?
Yes.
All right, thank you. Mr. Nicolosi, good morning.
Good morning.
Your attorney, Barry Roderman, is not here. You have a couple of options. You can go forward with the services of the public defender's office this morning, or you can have me roll your case over until tomorrow and someone can try to reach him. But I don't see a Barry Roderman in the Florida Bar Directory.
Does he maybe mean Glenn Rodham?
Does he mean, do you mean Glenn Roderman?
No, his name is, I'm pretty sure it's Barry. I mean, that's the number I got. My family hired him.
Okay, there's no Barry Roderman in the Florida Bar Directory, so there's nobody that we can contact to let know that you're here this morning.
All right, well, maybe it is Glenn. I know he has an office here in Fort Lauderdale.
Okay, let me pull up Mr. Glenn Roderman's name and see if, ask you for the phone number, just.
I have his number, Your Honor, if you want me to reach
I
out.
want to see if it's the same number,
Okay, gotcha.
because then that would solve our confusion. I just spelled Roderman. Am I spelling his name wrong? It's not pulling it up. That's what I typed in. Hold on. Okay, I found a Barry Roderman. For some reason, it wasn't pulling up before. Okay, so I do have a Barry Roderman. Mr. Linder, can you or Ms. Kadashi please give him a call, and we'll see if we can put Mr. Nicolosi to the end of the docket. All right, so we're going to put you on a brief recall, sir. The state attorney in the courtroom is going to do me a courtesy and try to contact your attorney and see if he can be here today. Otherwise, we'll see you tomorrow, okay?
Thank you, Your Honor.
All right, take a seat. Thanks. It's do you need the number? The office number is 954. Oh, sorry. All right, so he's on the phone call. I don't know if he can multitask. All right, thank you for calling, Mr. Linder. What did his office say?
I'm sending his paralegal right now.
Okay, thank you. All right, so next is Mr. Gianti on page 10 while we're waiting on that.
Mr. Gianti is here present, Judge Amain.
All right, thank you. All right, sir, good morning. I do find probable cause for this petty theft, first degree, property over 100, less than 750. It looks like he has no bond holds, correct, Mr. Linder?
Actually, I'm showing that he was county sentenced on a VOP. His release date is 11/4/21. So considering this offense potentially involves restitution, I don't have an offer. I'm just asking the court to keep the bond in place.
Okay, thank you. Mr. Romero?
Judge, just heard, I believe, Mr. Lender said there's restitution, so I did advise Mr. Gianti. He was interested in resolving. I told him the only way probably we wouldn't be able to if there were some restitution issues. So therefore, no request at this time, Judge. I know he's going to be held in custody. He already told me he was sentenced on a VOP till November.
Does your office need to be provisionally appointed?
Yes, Judge.
All right, thank you so much. So I will leave the bond in place with an order of no return to the target in the police reports. That's 1200 South Federal Highway in Deerfield Beach. And I'll provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID's over, you'll need to reapply. Good luck to you, Mr. Janty. All right, next is Mr. Arnold. Do you guys have a cart there yet? Because they said we might have to take him out of order.
Yes, ma'am, we're ready, Your Honor.
Okay, perfect. There we go. All right, Mr. Arnold, good morning, sir. Ms. Carr is here on your behalf. I do find probable cause for your municipal ordinances for trespassing and violation of an alcoholic beverage. Ms. Carr, did you have an opportunity to speak with him?
No, Your Honor, I did not, just based on the nature of where he was located. However, if Your Honor is inclined to extend an offer, I would ask Mr. Arnold if he would like to resolve his case today to an adjudication and time served in exchange for a no contest plea.
They said he was having severe mental health issues this morning, Ms. Carr, so I cannot extend one. What I can do, though, is transfer him to Judge Lerner Wren's Mental Health Division, order a mental health screen, and provisionally appoint your office.
That sounds great. Thank you, Your Honor. And I would just ask the bond to remain in place.
All right, not a problem. So I will do that, an order of no return to the Walgreens and the police reports, transfer his case to the Mental Health Division, and order that mental health screen. Do you mind emailing me one with your appointment?
Yes, Judge, I don't have a copy of the standard one that Your Honor uses, but I can draft one.
That's fine. Not a problem, Ms. Carr. Thank you so much.
Thank you. Have a nice day.
You too. Is that it for you?
I believe so, unless there's anything on the second look docket that I'm not aware of.
Nope, we did all of those. So thank you. Have a great weekend.
You too.
Thank you so much. All right, so next is Mr. Judicial.
He's approaching, Judge, in Maine.
All right, thank you. All right, sir, good morning. I do find probable cause for leaving the scene of a crash involving damage to property and operating without a valid driver's license. Mr. Linder?
Judge, I'm not seeing any history. Based on the allegations, I'm recommending an ROR to pretrial.
Okay, thank you. Mr. Romero?
That's exactly what we were going to be asking for, considering at this time he has no priors, and we're going to be asking to be provisionally appointed on his case, however.
All right, thank you. So, sir, you are going to be released a pretrial release on the entire case. That means that you're going to get out today, but you have to call in before Monday before 11 a.m. So please give your phone number to pretrial before I continue with my orders.
954-934-2878.
All right, did you get that, Ms. Brown?
934.
934 were the last three?
2878.
2878. All right, no problem. Sir, you cannot drive without a valid driver's license while your case is pending. Do you understand? Sorry, is that a yes?
Yes, ma'am.
All right, no problem. Anything else on his case that we need to address?
No, Judge.
All right, good luck to you, sir. Call in on Monday. You're going to get out. All right, next is Mr. Santa-Loki on page 10.
He's here, present, Judge, approaching.
All right, thank you, sir. Good morning. I do find probable cause for petty theft, first degree, over 100 to less than 750. Mr. Linder, does the state have an offer if he wishes to resolve?
I do, Your Honor. The offer is adjudication, time served, no return. Looks like he was just arrested on Sunday for resisting without violence and trespass and pled that out at first appearance trial.
Okay, thank you. Mr. Romero?
Judge, I spoke to Mr. Santa-Loki. At this time, he wishes to accept the state's offer in exchange for his no contest plea, receive it to served off.
Oh, okay, sorry, I didn't mean to cut you off. All right, thank you.
apologize for interrupting the court. My name is Barry Rotterman. I have been retained to represent Mr. Nicolosi. I would go along with that plea immediately.
Judge, I hear some speaking. Oh, there's
Mr. Rotterman, your volume is very low, but we're in the middle of a plea. I'll recall your client, Mr. Nicolosi, after this plea, okay? Thank you for joining us.
Yes, ma'am. Thank you.
You need to turn your volume up when we do come back to you because I can barely hear you, okay? So just figure out those audio issues in between and we'll come back to you, okay?
Very good. Thank you, Your Honor.
Thank you. All right, Mr. Santa-Loki, please raise your right hand for me to the best of your ability. Your next right. Your next right. There you go. All right. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. You can put your hand down and please state your name for the record.
Andreas Santa-Lucia.
All right, sir. It's my understanding you wish to resolve your petty theft case, correct?
Yeah.
And do you understand the charge against you?
Yeah.
And do you understand everything that's happened here today?
Yeah.
Is anyone forcing you to resolve this case? Are you under the influence of alcohol or drugs, sir?
No.
Do you need more time to speak to your attorney? Do you understand you have a right to go to trial, but you're forever giving that right up by accepting the state's offer? Have you ever been treated for a mental or emotional illness, sir?
He answered in the affirmative.
Yes. Okay. So is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
All right. And I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you are not a United States citizen that taking a plea today shall subject you to deportation proceedings, sir? And I must also advise you that upon a third arrest after 2 convictions for petty theft, you may be charged with a felony petty theft, and it may result in you receiving jail or prison time. Do you understand? All right. And how do you wish to plead, sir? Guilty or no contest?
What's your plea, sir? Guilty.
All right, sir, accept your guilty plea is freely, voluntarily, knowingly given. I also find there's a factual basis for this plea based on the probable cause affidavit. I will sentence you to an adjudication, time served, and no return to the 7-Eleven in the police reports. How much time does he need to pay Mr. Romero?
Judge, I'm going to be requesting civil lien.
All right, and I'll convert your court costs, cost of prosecution, PD application fee to a civil lien, Mr. Santa-Lucia. What that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you have to pay that off. Good luck to you, sir. You should be released today if nothing else is holding you. All right, so let's recall Mr. Nicolosi on page 9. His attorney is here.
Approaching, Judge.
All right, thank you. There's, Ross, there's just no name on Tolbert if you don't mind adding that in. Oh. Mr. Linder, do you have the name for Tolbert to hand to Raj? Okay, thank you. I'm going to hand it. He's going to give it to you. All right, Mr. Nicolosi, again, your attorney, Mr. Rotterman, is here. We were able to find him and he has logged on. So good morning again.
Morning.
All right, I do find probable cause for battery, second or subsequent offense. Once Mr. Linder gets back, Mr. You first, sir, for those priors, and then a recommendation. He has it. Yeah, Roger's.
Your Honor, I'm recommending a $7,500 bond, no victim contact. It's based on the level of violence alleged. His history, he had while dated, he was convicted of domestic violence battery in 07 against the same alleged victim. He was arrested in 04 for domestic violence battery against the same alleged victim that was dropped. In the late 80s, he was convicted of 3 separate strong arm robberies, sentenced to 4.5 years state prison. I would also note, I'm obviously not familiar with Mr. Nicolosi's current living situation, but I would note he was arrested in the state of Oregon on this warrant and extradited from Oregon. Nothing further, Judge.
All right, thank you, Mr. Rotterman.
Mr. Nicolosi had some criminal convictions and problems like 20 years ago, but currently he's working in the Maritime Union. He's supporting 4 kids and his ex-wife that was the victim herein. I've spoken to her. I've spoken to Mr. Nicolosi at length. He just got done being extradited from the state of Washington. Oregon, where he was incarcerated for, I don't know, 10 days, 12 days. So I would submit he's been gainfully employed. He hasn't lost his job. I've said, I've talked to his superiors, and And I would just ask that the judge, he would go along with the plea, but I'd ask for a withheld adjudication, which puts him on notice that he's got to walk the straight and narrow. He's divorced from his wife. He got divorced a couple of weeks ago. It's unfortunate this happened. If she testified, she would minimize the but you know, they had this argument. They wound up spending the night together that night. And like I said, they're divorced, but he has been severely punished just by the way he's been extradited and arrested. The only difference, I would accept everything that the state is providing. I would just ask this court to accept the no process. I mean, the plea of no contest.
Oh, okay. Thank you, Mr. Roderman. I can't accept this is a felony and the state has not yet filed an information, but what I will do is I will instate the $7,500 bond agreed to by the parties. The condition of your bond, Mr. Nicolosi, even while you're in custody, you cannot have any contact with the listed victim, direct or indirect, until further order of the court. Do you understand?
Yes, ma'am.
That means that you cannot live with her, call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes, ma'am.
All right, and your attorney is here representing you. Anything else on his case that we need to address?
No, Judge.
All right, thank you. Good luck to you, sir. Thank you, Mr. Roderman, for logging on so expeditiously.
Thank you, Judge, for your courtesies.
All right, so next is Mr. Lesperance on page 10.
He's approaching Judge here, Maine.
Okay, thank you. Good morning, sir. I do find probable cause for petty theft, degree, second offense at a Home Depot. Mr. Linder, does the state have an offer if he wishes to resolve?
Offered being adjudication, time served, no return, Judge.
Okay, thank you.
Judge, that's exactly what this gentleman wants to accept in exchange for no contest plea.
All right, thank you. Please raise your right hand for me, sir, to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your hand down and please state your name for the record now. Do you swear or affirm to do you understand the charge against you, the petty theft?
Yes.
And it's my understanding that you wish to resolve this case, correct?
Yes.
Do you understand everything we've discussed today?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of alcohol or drugs?
No.
Do you need more time to speak to your attorney?
No.
Do you understand that you're forever giving up your right to go to trial by accepting the state's offer?
Yes.
And have you ever been treated for mental or emotional illness?
No.
I'm not asking if you're a citizen. I just have to advise you. Do you understand if you're not a United States citizen that taking this plea today shall subject you to deportation proceedings?
Yes, I understand.
And I also must advise you that this is your at least second conviction for petty theft. Upon a third arrest or any other arrest for petty theft, you could be charged with a felony, which could result in jail or prison time. Do you understand that?
Yes, I understand.
And how do you wish to plead, sir? Guilty or no contest?
Contest.
All right, sir, except your no contest plea is freely, voluntarily, knowingly given. I also find there's a factual basis for this plea based on the probable cause affidavit, and I will sentence you to an adjudication time served with an order of no return to the Home Depot in the police report. How much time does he need to pay, Mr. Romero?
I'm going to be asking for a civil lien, Judge.
All right, not a problem. I will convert your court cost of prosecution, PD application fee to a civil lien. What that means, sir, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay this off. Good luck to you, Mr. Lesperance. If nothing else is holding you, you should be released today. All right, next on page 11 is Mr. Arnold.
He's approaching Judge here, Maine.
All right, thank you, Mr. Arnold. Good morning, sir.
Okay.
I do find probable cause for trespassing. It's at a Beacon Light Plaza, Mr. Linder. Does the state have an offer if he wishes to resolve?
Adjudication, time served, no return, Judge.
Okay, thank you, Mr. Romero.
Judge, it's being Mr. Arnold. That's what he wanted to accept in exchange for his no contest plea.
All right, thank you, sir. Please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? Sorry, you need to speak up a little louder.
He answered in the affirmative.
All right, sir, you need to step up and speak a little louder. You're soft-spoken. You can put your hand down and please state your name for the record.
Larry Arnold.
All right, Mr. Arnold, it's my understanding you wish to resolve your trespass case, correct?
Yes, ma'am.
Do you understand the charge against you?
Yes, ma'am.
And do you understand everything that's happened here today?
ma'am.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of alcohol or drugs?
No.
Do you need more time to speak to your attorney?
No.
Do you understand you have a right to go to trial, but you're forever giving that up by accepting the state's offer?
Yeah.
Sorry?
Yeah.
All right, have you ever been treated for a mental or emotional illness, sir?
No.
And I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen that taking a plea today shall subject you to deportation proceedings?
Yeah.
And how do you wish to plead, sir? Guilty or no contest?
No contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given. I find there's a factual basis for this plea based on the probable cause affidavits. I'll sentence you to an adjudication, time served, no return to the Beacon Light Plaza. And Mr. Romero, how much time does he need to pay?
Judge, I'm going to be asking for a civil lien based on him advising me he's homeless and not working.
All right, not a problem. I'll convert your court cost of prosecution, PD application fee to a civil lien, Mr. Arnold. What that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay those off. Good luck to you, Mr. Arnold. If nothing else is holding you, you should be released today.
Good luck, sir. Thank you.
All right, next is Mr. O'Shea on page 11, who's waived his presence.
Yes, Judge, but I'm going to be asking for two things. I'm going to be asking for a medical screening order and a phone order, Judge.
All right, no problem. I will sign those both. And I also do find probable cause for his KPS for driving with license suspended, but that's an ROR, and his violation of probation over DUI with property or injury damage. And that's a $500 bond. I'm not going to touch those orders, that bond amount. You'll have to go before his division judge to address that. Does your office need to be provisionally appointed on both of these cases?
Yes, Judge.
All right, so I will sign again both the orders, and I'll provisionally appoint your office to represent him during the pandemic. Anything else on his case?
Nothing else, Judge.
All right, thank you. That takes care of Mr. O'Shea. Now on page 12, Mr. Smith, who's also waived his presence. All right, thank you. The court, I do find probable cause for his out-of-county holds from Miami-Dade County. He's going to be held no bond and transported to Dade County to answer to the counts of grand theft, a lot of grand thefts and grand theft VOPs. Anything else on Mr. Smith's case? Okay, hearing nothing else, that takes care of Mr. Smith. That brings us to Mr. Contreras on page 12, who's waived his presence.
That is correct, Judge.
All right, thank you. I am going to find probable cause for his immigration hold. He's being held no bond on that hold. Anything else we need to address on Mr. Contreras?
No, Judge.
All right, thank you. Next on page 13 and 20, Mr. Jones has two separate sets of cases, and I believe he's waived.
That is correct, Judge, but I'm going to be also asking for a medical screening order on his behalf.
All right, not a problem. So I do find probable cause, medical screen order. All right, I do find probable cause for the possession of fentanyl on page 20 and for his two violation of pretrial warrants on page 13. And I will leave the bonds in place because he has the violation of pretrial warrants. And Mr. Romero, does your office need to be appointed in all two cases?
Yes, Judge.
Okay, and I'll provisionally appoint your office to represent him on both cases, and I'll sign the medical screen order on both. Anything else?
Nothing else, Judge.
Okay, let me just write it on my docket as well. Medical screen order and waive. All right, thank you. That brings us to page 13, Mr. Cordington.
He's here present to my left.
Okay, thank you, sir. Good morning. I do find probable cause for count 1, grand theft of a firearm, count 2, grand theft auto, count 3, carrying a concealed firearm, count 4, false ID to Leo, and count 5, possession of weapon or ammunition by convicted felon. Mr. Linder, first to you.
And Your Honor, just for the record, actually, and I know it's in the PC, his name is Christopher Durham, Your Honor.
Right, I did see that. So do I write an AKA on this finding, Ms. Cooper? Since he used somebody else's name.
No, sir. No, you leave it. It's based on the DCCN number.
Yeah.
So you leave it.
Okay, thank you. Okay, so his priors, Mr. Linder?
Yes, Your Honor. I'm showing, no. I'm showing a 2017 robbery with a firearm, 2015 grand theft auto, theft 2015, battery 2014, resisting without violence 07. Your Honor. I would argue, I'm recommending a $7,500 bond on charge 5, no victim contact, no firearms, weapons, or ammunition. I would argue it's aggravating that he didn't just use or make up some false name. He actually was trying to use the identity of another individual, that he was actually in possession of this individual's identification. If law enforcement didn't figure this out, there could have ended up being an eventual warrant for this individual, this innocent individual, Your Honor, based on Mr. Durham's attempts. Nothing further.
Thank you, Mr. Romero.
Judge, and speaking to this gentleman, he's been residing in South Florida his whole life. At this time, he's not working. He advised me he's been actively looking, but unsuccessful. In Pompano, my understanding is his mother is the only person that he can turn to, but she doesn't work. She gets disability. He believes using the services of a bondsman, the most that his mother would be able to afford would be a total bond of $2,000. That's what we're going to be asking for, Judge. We're going to be asking to be provisionally appointed on this gentleman's behalf.
All right, thank you. So I understand what he can afford. However, I do have to consider the danger to the community he poses. And some of the dangers include not only the prior conviction for a robbery of firearm as recently as 2017, and being in possession of a stolen firearm while a convicted felon. But it's alleged that this automobile was stolen in a carjacking just 2 days prior to his arrest. So I am going to set bond on count 5 at $5,000. I will leave the bonds in place on 1 through 4. Sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
You also cannot have any contact with the listed victim of the grand theft auto or carjacking, direct or indirect. Do you understand?
Yes.
You may not know who they are, but you cannot call them, text them, email, social media, have a family member or friend send a message to them, or any other means of communication that I have not said. Do you understand? I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else in Mr. Cordington's case?
Nothing else, Judge.
Recollect you, sir. Next is Mr. Scott on page 14, who's not only his presence is waived, but his attorney has waived his presence as well. So we're going to do Mr. Christopher Scott in absentia. I do find probable cause counts 1 through 5, direct promote sexual performance by a child, count 1, direct promote sexual performance by a child, count 2, direct promote sexual performance by a child, count 3, count 4 and 5, also the same counts, direct promote sexual performance by a child. I do know that his division judge has already set bond, and he was advised of the bond and bond release conditions. Judge McCarthy uploaded them to Odyssey on June 24th of 2021. So I am going to reinstate the bonds as that Judge McCarthy has set, since she is the division judge. So it'll be the bond amounts that she set with pretrial release level 2 with a GPS. He cannot have any contact with any of the victims, direct or indirect. He cannot have any contact with minors. He shall not work in a setting involving minors. He cannot use any social media, including but not limited to Facebook, Snapchat, Instagram, Twitter, or TikTok. No dating apps, no encrypted apps, including but not limited to Telegram and WhatsApp. No pornographic websites. He shall not install Net Nanny or other content controlling application on any smart devices. He's prohibited from wiping software, forensic cleaning smartware on smart devices, prohibited from deleting browser history and or screen usage history, and his devices may be randomly searched by pretrial officers. And he's permitted to work at Barnes & Noble and shall give his schedule and location to pretrial. So she allowed him to keep smart electronic devices.
Your Honor, all I can say is, I mean, obviously I wasn't there, so all I can say is whatever's in the order is, I imagine, what Judge McCarthy ordered. I did speak to Ms. Butler from my office and Mr. Z yesterday. They advised me that what's in the order is accurate. They actually tried to surrender him at the jail on multiple occasions, but they were unable to with the order. And that's why he ultimately was surrendered in court, Your Honor, just yesterday.
All right, Mr. Lunar, anything else that I missed?
I don't believe so, Your Honor.
All right, for some reason, he still has a phone despite these charges. That's his division judge's orders. I'm not gonna change them because I have.
The only order that we received was remanding him in custody.
I just printed out a copy and I gave it to Miss Brown. If you want her to hand that over to you, it's an Odyssey when she's done. So you have it
So
for your,
it has bonds?
it has, she said the bonds.
So for the record, you just read the bonds so I can put them back in?
1 through 5, she only said it $1,000 each. She sure did. All
And
right,
Your-
thanks, Mr. Scott.
And Your Honor, just,
I mean, no pretense.
I can't, I don't have any authority to change it. That's the division judge. All right, anything else in that case? If not, we're moving on. All right, next on page 15 is Mr. Gray. All right, Mr. Gray, good morning, sir. I do find probable cause for your out-of-county hold from Palm Beach County regarding dealing in stolen property and grand theft. You're being held no bond. Palm Beach County is informed that you're ready for pickup. Anything else on his case that we need to handle?
Judge, yes, Mr. Gray just wanted to know the answer to this question. Maybe pre-trial can let us know. He understands as far as the out-of-county hold from Palm Beach, nothing we can do. Palm Beach has to come and pick him up. However, he did advise me, he wanted me to bring this up to the court, that he was out on a separate unrelated case, and he was out on pre-trial, and he wanted to know, he was placed, I believe, on level 2. So he's going to be transported to Palm Beach. If he convinces his judge up there to let him go, how is he going to be placed back on pre-trial?
Ms. Brown?
You know, the jail can run him and go back.
He wants to know, and once they removed the animal belt, they brought him in on the out of county hold, so it will be up to pre-trial to revoke the pre-trial, then he would have to go to Palm Beach with a detainer to come back to Broward. If the pre-trial is revoked, he has to be on Elmo.
if it can't be revoked, and I understand if it's another county's GPS monitor that the jail can't put a hold, but if it's a Broward County GPS,
Is it Broward County?
Yes, the GPSs.
Okay, so he would have to go to Palm Beach with a detainer, but the only way that would happen, pre-trial would have to go. The case that he's on the Elmo.
but if it's revoked, how can there be a detainer on it?
He's on pre-trial. He has an order, but he's still in custody. Right, but he's on. He's on the inside. On the out of county hold for Palm Beach. They removed the animal at the time. If he's born Palm Beach, he has to come back and be assessed with the animal. You have to bring him back in custody on the pre-trial hold. And then he'll take care of our case before he even goes. If you don't do that, he's gonna go to Palm Beach.
I
Have an automatic inclusion.
I suspect from what I'm hearing, pretrial is going to have to seek an order from the assigned judge that he be brought back from Palm Beach to have the monitor put back on.
Okay.
Judge, we didn't hear anything what happened.
There's a lot of back and forth, but it looks like pretrial needs to get an order from the division judge in order to have an order put in his court file and into BSO to bring him back. So he can get fitted with an ankle monitor should his no bond hold be released in Palm Beach, okay? All right, good luck to you, sir. All right, next is Mr. O'Neill on page 15, who's waived his presence. I do find probable cause for his out of county hold in Palm Beach County. Again, he's being held no bond as well. Hopefully it's nothing as confusing and he can just be transported to Palm Beach for his burglary of a structure and grand theft over 10,000. Anything else in Mr. O'Neill's case?
No, Judge.
Thank you. Next is Mr. Tuff on page 15, who refused, but we're proceeding without him based on the level of violence.
And that would be over defense objection.
Okay, what's the legal objection?
Judge, I don't know, sometimes, as you're well aware, sometimes these individuals are actually sick, and it's not a refusal, it's that they're sick, and I do not know, and I believe the court does not know at this time.
All right, thank you. I was advised it was a refusal, so based on that, we're going forward. Okay, thank you. So I actually do find probable cause as well for aggravated battery with a deadly weapon because he used allegedly a pipe and which at the victim's head, but it struck her hand that she was using to protect herself. Ms. Edgley, any legal objection, ma'am?
Judge, I have no legal objection.
Okay, thank you. So it will be aggravated battery, deadly weapon. Mr. Linder, first to you, sir. Let me turn this down. Oh, hold on, sorry. Mr. Brown, first to you, ma'am, since you have the hand raised.
Judge, Mr. Tuff is being supervised by pretrial in case number 190105575 CF10A for possession of utilone, possession of drug paraphernalia, and possession of cathinones. We are asking for supervision to be revoked due to the new arrest.
All right, thank you. Mr. Linder, your position first.
Your Honor, I'm asking first that the court revoke his pretrial, set the bond back on possession of utilone and substituted cathinones at 1,000 each. No bond to be attached to the drug paraphernalia. On the new case, Your Honor, I'm asking for a $10,000 bond, no victim contact, no weapons. Based on the level of violence, the pending felony from 2019. Additionally, his history includes unlawful use of false name ID 2018, possession of cocaine 2018, possession of cocaine 2017, 14-month state prison, possession of cocaine 2014, 21.5 months state prison, another possession of cocaine in 2014, multiple priors for possession of cocaine, Your Honor. In addition to that, nothing further.
Okay, thank you. Mr. Romero?
Judge, I'm asking at this time for the court not to take any action on the case he's currently out on pretrial. From my understanding, I believe the case that he's currently out on pretrial, they're nonviolent in nature, so they're unrelated offenses. I believe the majority of his priors seem to be nonviolent drug offenses. I'm going to be asking on the new law offense for the court to consider a $2,000 bond. If the court is inclined to take action, I'm going to be asking on his on the 2019 case, since they're all nonviolent, I'm going to be asking for a total of $1,000 bond and to be provisionally appointed on Mr. Tuff's case.
All right, thank you. So I will provisionally appoint your office to represent him during the pandemic. Based on the level of violence, the allegation that the illicit victim had a laceration on her face, allegedly from being punched 5 times in the face, and then struck with a pipe. I am going to set bond in the amount of $10,000, no victim contact, direct or indirect, no weapons while his case is pending. Ms. Cooper, please make sure that confinement gives him that order so that he knows he cannot even contact the listed victim while he's in custody. And I will grant pretrial's request and set bond on the 2 drug offenses at $1,000 each, ROR on the drug paraphernalia. Okay, thank you. That brings us to Mr. Sandonato on page 15, who's waived his presence.
That is correct, Judge.
All right, thank you. Oh, sorry, this is really low. I couldn't hear you. All right, so I'm going to find probable cause for his violation of parole. He's being held no bond, and the parole board will have to make a determination as to whether they're going to bring him. Okay, that brings us to Mr. Osborne on page 16, who's refused, but there was no legal reason why we couldn't proceed.
Correct, Judge.
All right, thank you. I do find probable cause for his out-of-county hold from Dade County. He's going to be held no bond and transported there to answer to firearm by felon or adjudicated delinquent. Anything else on his case?
No, Judge.
All right, thank you. Next is Mr. Peterson on page 16, who's waived his presence.
That is correct, Judge.
All right, thank you. I find probable cause for license plate, et cetera, possession counterfeit, carrying a concealed firearm, driving under the influence with damage to property or person of another, allegedly at 8:55 in the morning, 4, operating without a valid driver's license. 5, 6, 7, and 8 are all capiouses. 5 is the no bond hold, not for me to change. 6, 7, and 8 all have bond amounts attached that he has to go to his division judge to address. I will provisionally appoint the office of the public defender. I will leave the bonds in place, but once he does post bond, he's going to be supervised by standard pretrial release. He will need to be randomly screened for drugs and alcohol while his case is pending. He cannot use any drugs, he cannot use any alcohol, and he cannot drive without a valid driver's license. Anything else on his case that we need to address?
Judge, if I may, just as a probable cause for count 3, which is the DUI, I would note that on the probable cause affidavit, it indicates that he did give a breath alcohol sample that was under 0.05. I would direct the court to the standard jury instructions that indicate that if there is a blood or breath alcohol level less of 0.05 or less, you shall presume the defendant was not under the influence of an alcoholic beverage to the extent that his or her normal faculties were impaired. And so I would ask the court not to find probable cause here. We do know that there was an accident prior to him being located unconscious in the vehicle. And so I would argue, Judge, that the observations made by the officer as far as clues of impairment during the field sobriety exercises can easily be related to the accident rather than impairment. So I'd ask the court to find no probable cause on the DUI.
Respectfully, he also indicated that he used cannabis in addition to the bottle of wine that he advised the officers he drank. So I am going to maintain my finding the urine is pending. If the urine comes back and there's no cannabis, then that'll be another argument for the filing attorney, okay? Okay, thank you. Anything else in Mr. Peterson's case?
Judge, you said count 1 to 4, transgender,
Yes, ma'am.
randoms, and no driving.
No driving while the case is pending. Actually, I did miss no firearms, weapons, or ammunition while his case is pending as well, based on the CCF. So there will be an order of no firearms, weapons, or ammunition as well.
And the bonds remain?
Yep, the bonds remain in place because he has that no bond hold on count 5. That's not for magistrate. So his division judge will need to address 1 through 4.
And he's not driving, Judge?
Nope, he waived. Okay, not a problem. Anything else? All right. All right, so next is Mr. Reeves on page 17.
He's approaching, Judge.
Okay, thank you. All right, Mr. Reeves, good morning, sir. I do find probable cause for distributing or delivery of cocaine. Mr. Linder, first to you, please.
Your Honor, I'm requesting a $5,000 bond pretrial release for the GPS monitor level 2 with an order of no return to the incident location. Your Honor, I can advise the court that I did speak with law enforcement this morning from FLPD. As mentioned in the report, Your Honor, this occurred at the bus terminal downtown. That has become a troublesome area for drug dealing recently, Your Honor. That specific location. So from what law enforcement advised me, they do have a concern for community safety. Additionally, Your Honor, as far as his local history, I'm showing 2012 possession of cocaine, 2012 possession of cocaine, 2006 possession of cocaine, 4-year state prison. 1989, armed burglary of a structure, 3 counts of aggravated assault, criminal mischief, and battery. He was sentenced to 17 years state prison after a violation of probation. 1990, he had 2 separate arson cases. He was sentenced to 14 years in state prison on each case to run concurrent. I'm also showing that he has a warrant out of the state of New Jersey from 2018 for violation of a court order. It is a local extradition only. Just seeing if there's anything else. Nothing further, Judge.
Okay, thank you. Mr. Romero?
Judge, Mr. Reeves has been residing in our community his whole entire life. At this time, he's not working. He gets disability. He lives in Fort Lauderdale, been living at the same apartment for 1.5 years. Judge, I just spoke to Mr. Reeves. He does not know what the state referred to as far as the out-of-state warrant. He knows nothing about that, but From what I did hear, all his, I believe the last time he had contact with the criminal justice system was approximately 9 years ago, and they were simple possessions. Now, I know he had serious priors, but they were well over 20 years ago, Judge. So no history as far as delivery or distribution. They were simple possessions. At this time, he did advise me that he's going to try and see if his family can help post his monetary bond. We're going to be asking for standard pretrial, but if not, he believes that maybe using the services of bondsman, he can afford, if the court were to consider a bond reduction to $1,000. We're going to be asking to be provisionally appointed on Mr. Reeves' behalf.
All right, thank you. I will leave the bond in place with an order of no return. I do find that he's a danger based on the allegations he was selling cocaine and allegedly sold it to a confidential informant. Sir, you cannot return to the incident location as a condition of your bond. Do you understand? I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Reeves. Once COVID is over, you will need to reapply to make sure that they keep representing you. That's just straight bond. Good luck to you, Mr. Reeves. I did. All right, next, Mr. Brandow on page 17 is a first-time refusal, nonviolent. He'll be given one opportunity and reset until tomorrow. Next is Mr. Joseph on page 18, who was refused, but there was no legal reason why we could not proceed. Thank you. I do find probable cause. Count 1 is a false name to Leo. Count 2 is drug paraphernalia. Count 3 is a violation of probation misdemeanor for $1,000 that I'm not going to touch. Counts 4 and 5 are violations of probation felony cases that are no bond that I'm not going to touch. And I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Anything else in Mr. Joseph's case?
Nothing else, Judge.
Okay, thank you. That brings us to Mr. We did Reno.
What happened to Nicholas Brandon?
He's a refusal. He's up tomorrow. Okay, next is Mr. Butler on page 18, who's also a refusal. So he'll be reset tomorrow, nonviolent in nature. I don't have the paperwork for Mr. Retta. Oh, there it is. Thank you. All right, next is Mr. Retta on page 19, who is a refusal, but there's no legal reason why we cannot proceed.
Correct, Judge.
All right, thank you. These are all out of county holds from Palm Beach County. He has on counts 28 and 29, $7,500 bond each. On counts 30, 31, and 32, it's no bond. Anything else on Mr. Retta's case? Okay, last but not least is Mr. Ziguri on page 20.
Is here present, Judge?
All right, thank you. Good morning, sir. I do find probable cause for possession of cocaine, drug paraphernalia, and tampering with or fabricating physical evidence. Mr. Linder, first to you.
Judge, asking that the court keep the bond in place on 1 and 3, ROR on count 2. Mr. Ziguri is out on bond right now for a pending grand theft auto from last year.
Okay, thank you. Mr. Romero.
Judge, based on that, no objection at this time. I'm going to be asking for a property order and to be provisionally appointed on his case.
All right, thank you. You cannot return to the incident location, Mr. Ziguri. That's a condition of your bond. Do you understand?
Yes, Your Honor.
All right, I will leave the bonds in place on 1 and 3, but I will ROR you on count 2, and I'll provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, if this case is still pending, you will need to reapply, okay? Good luck to you, Mr. Ziguri. All right, guys, that's it for the docket. Do we have any questions? It's our last on Zoom. It's our last Zoom, guys. Sorry, what pages? 17 and 18. Okay, what 17 Brandow, you mean? Clayton is deleted because it's it's only a VOP, so that went to his division. We proceeded. I left the bonds in place. Butler was a refusal. He'll be up tomorrow. Any other questions? Okay, yeah, no, we talked about it. Mr. Romero, do you want me to bring you to a breakout room so we can talk about the quarantine procedure? We figured it out last night.
Please, thank you.
All right, no problem. So I will, I guess I can bring us into a breakout room. No
so
problem.
Judge Blackman, will you let us know at the jails?
We're gonna do, well, I'll just do, we're gonna do Zoom at the end of the docket. We're going to have a new Zoom link because this one is going to be a dead link, so we don't have Zoom bombers anymore.
Okay.
It's only going to be for quarantine, and we're gonna take all of those cases at the end because we don't want you guys to have to sanitize and spend the resources and time having to sanitize each night before the next morning and putting everybody else at risk. So we're gonna do the Zoom, okay?
Okay, thank you very much.
Figuring out which Zoom link, since you guys are all here, we just have to figure out which, we'll get you all the Zoom link, but please do not share. It is confidential because we do not want the Zoom bombing. This is why we're killing this link after this weekend, and it will be a brand new link so that it's just for quarantine cases. So everybody else has to come back in person if they want to watch, or YouTube is still available. It's not that we're going off YouTube, we're just going off of Zoom.
Okie dokie.
So I guess we don't need to go in the breakout room, so.
Sounds great, Judge.
All right, thanks. Have a good weekend. Have a good rest of your morning.
All right, have a good weekend, everyone.
You too, guys. Thank you.